Hello and welcome. In today's episode, we're going to be talking about the confidential information that you cannot share with your employees. And there's, or not. Woo! It's Tuesday early, relatively speaking. This is information that you cannot share with people outside of your employee and or your business if you are one. So these are you have to be very careful, and there's a lot of reasons for it, and we'll talk about those in just a minute. If you're new here, my name is Taylor Darcy from Think Legal, where I help you create the business of your dreams. So welcome. I look forward to getting to know you. Please feel free to stop by Monday through Friday, except for holidays, at 11 a.m. Tell your friends, tell your neighbors, tell your dogs. I would love it if someone brought their dog on here and took pictures and stuff. That'd be cool. I love dogs. Dogs are awesome. But tell your fellow business owners, because I'm here to help, and this is what I do. So anyway, also feel free to follow me on Facebook, Twitter, Instagram, everything. I am Think Legal PC on all of those. My website is thinklegalpc.com. I've just recently changed it, so that's exciting. And let's get started. All right, welcome back. So the first thing you have to know about employee privacy is that your confidential information is that it is enshrined in the California Constitution that people have a right to privacy, and was recently clarified a bit, not entirely, with the CCPA back in 2018, most of which took effect in 2020. And then the remaining portions of it took effect in 2021. So here we are. We're halfway through the year, almost. Woohoo! Can't believe it. It's crazy. We're halfway through 2021 and we don't have a new pandemic or a new killer bees or any that type of thing. Woo! Oh, my goodness. So anyway, I digress. So the reason that this is so important is that you have a right to privacy, generally speaking. There are some exceptions to rights to privacy, but one of which is when you seek out, like, for instance, movie stars have a reduced expectation of privacy. I am not saying eliminated, I'm saying reduced, right? Because they are seeking the spotlight. They want to be in that. Now, it's not a carte blanche. You can't just, say, oh, well, they're a star, so I can do whatever I want. No, they still have reasonable expectations of privacy within their home, within their property, just that type of thing. But for employers and employees, you as an employer, you have you have access to very private information. And the idea that what you want to make sure of is that you're not inadvertently or accidentally providing that private information to someone that you shouldn't, number one, and number two, that you're not collecting stuff that you don't have a reason to collect. There's a lot of it has to do with more of, why do you need that for me to do my job? Should you do a reasonable background? Yes, we've talked about that in other videos. Should you collect information about your employee? Absolutely, because getting to know your employee can create a great bond and a relationship between you and your employee. But you need to safeguard it. That's the most important part that I can tell you, is you need to safeguard the employee information, because you never know what could happen. If you have a breach of your network and employee information is compromised, they need to be notified of those things, as well as your consumers, your clients, customers, so that they can take proper actions to prevent any damage to their personal stuff. So for the point of the CCPA, which is the context of what we're looking at, it's defined as personal information that identifies, relates to, describes, is capable of being associated with, or could reasonably be linked directly or indirectly with a particular consumer or household. So it's pretty dang broad. Okay, that comes directly out of the CCPA. California Consumer Privacy Act is the actual name. Sorry, I should have said that before. Okay, so employers are required to tell the employee what private information that they are collecting and how it will be used. Okay, so you can't just collect stuff and then not tell them why you're collecting it. And like, for instance, social security number. Now, some of you are like, well, duh, I need it to pay them, right? And pay taxes. And that's fine. But you need to notify them of that. Same thing goes with driver's license, especially if there's no reason. If they're not driving for you, if they're not doing any driving ever, then do you have a need for their driver's license? Okay. Financial information, same thing. The list goes on, and I'll talk about the specific list of information that you can collect, and then what it means to each one. The next part is you cannot collect the information and then release it to anyone other than the employee or a third party with written authorization by them from the employee. So they have to give you written authorization showing that you are able to release that information to someone else. If they don't give you that authorization, you cannot release it to somebody else. That's just how it is. And here's the exception to that. Isn't it great? Law and everything always has exceptions. Woohoo! Anyway, is that if there's a subpoena from a government agency, if you receive a subpoena, you have to release the information to the government agency that's requesting it. That's just the other one, and again, that's the exception. But other than that, those three things: the employee, third party with employee authorization, or a subpoena. Other than, you cannot release information that is. Now, let's talk about the information that you collect and that cannot be released. Okay. Personnel files. So anything regarding the person, any application, notes, resume, anything that would be logical within that context of personnel file. So notes about the client, about the employee. So reviews, things of that nature cannot be released without their authorization. Any type of medical information from pre-employment background checks or ongoing background checks or medical checks, histories, health histories, anything that is that would normally be covered under HIPAA. This is not HIPAA because you're not a healthcare provider. This is just confidential information that you can't provide to anybody else. So medical information from pre-employment, medical exams during employment, any type of knowledge that you glean from them being employed with you, medical information. So for instance, say they are on light disability work because they broke something and they need some accommodations for that purpose. You can't release that to somebody that's asking you about it. Obviously, they'll see it if it's in person. But if someone's asking for medical records or medical information, you cannot release it without authorization or the subpoena. Okay. Biometric information. This one's a new one. So fingerprints, retina scans, any type of thing that could be linked to them. If you have a fingerprint scanner to log them into some sort of device, room, or otherwise, then you cannot release that scan or that information to them because it's personal to them. So anything that relates to their physical person, biometric stuff. The obvious ones, like we talked about a few minutes ago, is the social security number. Can't release that. Driver's license, same thing. Can't release any of this information without prior authorization. So just think about all of your personal private information, what you would want out there in the world, and do accordingly. Like, there's a lot of restrictions on that. So the next part of privacy isn't so much the information, so much as part of their doing their job. And in California, phone calls cannot be recorded or monitored without both parties' consent. And so in order to get that, you would need to notify you have to notify the person that you're recording. And typically in California, I've heard it done with beeps on the line to notify them that it is being recorded. But you also have to get authorization from the employee that they're okay with you recording them. And that's done in typical employment handbook, employee handbook or employee contract, any type of stuff that requires them to do their job. If it's not included in there, there can be some issues with that. So those are the big things about confidential information. I want you to think about that again in the context of what would you want shared and to not share accordingly. As an attorney, we have a heightened sense of what we can share or not share, and ours is even more restricted than that. We can't share personal information. Even more so, like it's even like we can't even acknowledge that a certain client works with us. So if you ask me, hey, do you work with so-and-so? The answer is no, I can't answer that for that reason, because of that confidentiality and attorney-client privilege that goes with them being my client. It's different with an employee-employer relationship, but it's still up there fairly high. So if you've gotten value out of this video, don't forget to hit subscribe, like, and remember we go live Monday through Friday at 11 a.m., except for holidays. Have a good one. Talk to you soon.